Two senators used their time to expose a pattern. Senator Sheldon Whitehouse said 50 U.S. attorneys were voted through en masse. The Senate was not told that one of them had been harshly rebuked by their own court 4 days earlier. Then, Senator Adam Schiff named a California prosecutor the grand jury sarcastically calls no bill. Watch the exchange first, then we'll step back and unpack what it really tells us.
Take my time this morning to say a word about U.S. attorneys and what's happened to this committee's role in the nomination of U.S. attorneys. Just recently, we had a U.S. attorney in an acting role who came before this committee and then went to the floor to be voted on as part of an en banc panel of around 50 different candidates, voted through en masse. We were not told that just 4 days earlier, I want to say, that U.S. attorney had been harshly rebuked by their home court for egregious abuse of their office. That's something we should have been told. We voted on a U.S. attorney, first hidden in the en masse vote, but second, without being informed of this development that had taken place of a rebuke, I believe, by the entire court, not just one irate judge, which puts a spotlight on the problem of how these interim and acting U.S. attorneys come up. We have seen over and over again illegal U.S. attorney appointments. And there's a general problem with that, which is that you'd like to see the Department of Justice follow the law, shouldn't be expecting too much. And when it doesn't follow the law with respect to the management of its own personnel, that's a pretty bad sign. And it is happening over and over and over again. And one of the prices that is paid when these illegal U.S. attorney appointments are made is that this committee loses its ability to have any oversight over their installation in that office. Our blue slips no longer matter. They don't get a proper hearing. They just get sent in under a variety of specious legal theories. And if this were done by a Democrat administration, I would think there'd be heads exploding the whole way down the panel. But we're absolutely silent about that. Now we have the U.S. attorney in Nevada, an article about her. I'd like to ask unanimous consent that we put that article into the record.
Without objection, so ordered.
A prosecutor who pushed to launch investigations at the behest of former clients and friends, while bypassing Justice Department orders recusing her from cases. She opened a probe targeting her past political foe, one of many circumstances in which she leveraged her role to advance personal interests. She frequently sought status updates on cases despite recusals that barred her involvement. She just, by the way, has publicly accused both of her home state senators of public corruption with no evidence for that. The letter goes on through the details of many of these various incidents, but it concludes by saying that she had assured the court and defense counsel in her district that she would cease supervising cases while her disqualification as U.S. attorney was under appeal. She is one of these illegally appointed U.S. attorneys. And despite having made that promise, and despite the recusal decisions from even the Deputy Attorney General's office, she has nonetheless remained involved. There is a very real mess in a lot of U.S. attorneys' offices around these nominees who are brought in illegally, who the courts have determined were appointed illegally, with potential risk to cases that are brought by illegally appointed acting or interim U.S. attorneys. And I think it's important that this committee takes some interest in that, because not only should we have a general interest in a Department of Justice that is breaking the law with respect to its own personnel matters, but we have a direct interest in this, in that the Constitution gives us the oversight authority to look into all of this and to police the appointment of potentially unqualified U.S. attorneys with our blue slips and with our hearings. And when we walk away from that responsibility, I think we've done something pretty grievous. So thank you for hearing me out on that, and my time has expired.
Mr. Chairman, may I just add on to...
Can you do it quickly, please?
Very quickly. I just wanted to add on to what Senator Whitehouse was saying. In the Central District of California, we have no U.S. attorney. We have no acting U.S. attorney, because the person who was acting, their tenure expired, and to get around the confirmation requirement, they have been made the first assistant U.S. attorney and are presumptively running the office from that post. This is someone who has demonstrated their unfitness for the job by going into the grand jury so often. His name is Bill Asaley, and getting a no bill, that is the grand jury refusing an indictment when the bar is only probable cause, that they have taken to calling him No Bill Asaley. It was reported in the LA Times that he was heard shouting at the Justice Department over the phone within earshot of the grand jury, vis-a-vis the Justice Manual's requirement that you don't seek an indictment unless you believe you can prove beyond a reasonable doubt someone's guilt at trial, shouting at the Justice Department over the phone that they can F the Justice Manual. And this is who's left in charge of this office, this very important office. So I just want to acknowledge the concern that Senator Whitehouse raised, and because we're seeing very much the same problem in California.
What this exchange was about is not the judicial nominee in the chair. It was about the pattern of how the administration is installing United States attorneys around the country. Senator Sheldon Whitehouse used his judiciary time to walk the committee through a specific case, where a U.S. attorney was voted through on an en banc panel of about 50 nominees, without senators being told that the same attorney had been harshly rebuked by their own home court 4 days earlier. He then named the Nevada U.S. attorney as a current example of a pattern that has now repeated across multiple jurisdictions. Then Senator Adam Schiff added a parallel case from California. Set the predicate. The Senate confirms U.S. attorneys through a process that is supposed to give the Judiciary Committee a meaningful look at each nominee individually. The committee's blue slip practice, which gives home state senators a meaningful role in vetting nominees, depends on that individual look. When 50 U.S. attorneys are bundled into a single en banc panel and voted through en masse, the individual look does not happen in any practical sense. Whitehouse used that en banc moment as the entry point to a much larger argument about the role the Judiciary Committee plays, or has stopped playing, in U.S. attorney confirmations. Whitehouse said that 4 days before the Senate voted on that particular U.S. attorney, the attorney had been harshly rebuked by their own home court. The rebuke was, Whitehouse said, not from one irate judge but from the entire court, and it was for what he described as egregious abuse of office. The Senate was not informed of the rebuke before the vote. That sequence is the heart of the argument. A U.S. attorney is an institutional officer of the federal court system. A rebuke of that officer by the relevant federal court is a material development that any reasonable Senate process would surface before confirmation. The hidden rebuke means the Senate voted without information it should have had. Whitehouse moved from that specific case to the broader pattern. The Judiciary Committee's blue slip practice, by which home state senators have a meaningful say in U.S. attorney confirmations, has been progressively bypassed. Acting and interim U.S. attorney appointments are being made in ways that, according to Whitehouse, fall outside the statutory framework Congress has set. The result is that the committee's oversight authority is being eroded one appointment at a time. Whitehouse said plainly that the blue slips no longer matter in practice. That is the kind of statement a senior senator makes when the institutional norm has shifted enough that it needs to be named on the record. Whitehouse raised a counterfactual that landed hard. If this pattern of appointments, he said, had been carried out by a Democratic administration, there would be heads exploding the whole way down the panel. The current pattern, by his account, is met with what he called silence. That counterfactual is not unique to Whitehouse. Senate watchers from both parties have observed for years that institutional outrage tends to track partisan alignment more than principle. Whitehouse used the counterfactual to surface the inconsistency, not to score a partisan point. The argument is that the committee should respond to the institutional erosion the same way regardless of which party is in the White House. Whitehouse then moved from the general argument to a specific current example. He asked unanimous consent to put an article about the Nevada U.S. attorney into the record. The article describes a prosecutor who pushed to launch investigations at the request of former clients and friends, while bypassing Justice Department orders that had formally recused her from those cases. According to the article, she opened a probe targeting a past political opponent, and she sought status updates on cases despite the recusals that barred her from involvement. Whitehouse noted that the article also reports she has publicly accused both her home state senators of public corruption, without supporting evidence. The most pointed detail from the Nevada case is the recusal pattern. The U.S. attorney had assured both the court and defense counsel in her district that she would cease supervising cases while her disqualification was under appeal. Despite that public commitment, and despite recusal decisions from the Deputy Attorney General's office, she remained involved in those cases. That sequence is not a marginal procedural failure. It is a fundamental departure from the basic structure of how federal prosecutors are supposed to operate when their fitness to handle a case has been formally questioned. Whitehouse used the Nevada example because it is concrete, recent, and well documented in a publicly available article. Whitehouse made the institutional point about why these appointments matter beyond the abstract. When a U.S. attorney is installed through a process the courts later determine was unlawful, every prosecution that attorney brings during that period becomes vulnerable to legal challenge. Defendants whose cases were brought under those circumstances can argue with some force that the prosecutor lacked the proper authority to bring the case. That argument can disturb convictions, settlements, and ongoing investigations long after the appointment itself is resolved. The downstream cost of unlawful appointments is not theoretical. It is borne by every case touched by the improperly installed attorney. Whitehouse closed his time by anchoring the argument in the Constitution. The Senate's advice and consent role is not a courtesy. It is a constitutional power. The committee's oversight of U.S. attorney appointments derives directly from that power and is the mechanism by which the Senate fulfills its assigned role in the appointments process. When the committee allows that role to be circumvented through bundled en banc votes, hidden rebukes, and acting designations that bypass confirmation, the institutional power the Constitution assigns to the Senate is functionally surrendered. Whitehouse called that surrender grievous. He closed his time, he yielded the floor. Senator Schiff then asked the chairman for a quick minute to add a parallel case. The Central District of California, which is one of the most populated and consequential federal districts in the country, currently has no confirmed U.S. attorney and no acting U.S. attorney. The person whose acting tenure expired was, by Schiff's account, made the first assistant U.S. attorney and is now presumptively running the office from that post. The maneuver, in Schiff's framing, is a workaround designed to bypass the confirmation process entirely. The committee's confirmation authority over the office is, in practical terms, no longer being exercised. Schiff named the official, Bill Essel. The choice to name him on the public record matters. It places the person at the center of the institutional concern Schiff was raising. According to Schiff, Mr. Essel has demonstrated unfitness for the post by going into the grand jury so often and getting what is called a no bill, which is the grand jury refusing to issue an indictment when the legal bar for an indictment is the relatively low standard of probable cause. The pattern, by Schiff's account, has been frequent enough that the grand jury has reportedly taken to calling him no bill Essel as a sardonic shorthand. A brief explanation of why a pattern of no bills matters. To indict a person in federal court, the grand jury must find probable cause to believe a crime has been committed. Probable cause is a deliberately low bar. It is meant to be a check against frivolous prosecutions, not a high evidentiary hurdle. When a federal prosecutor regularly fails to clear that bar, the natural inference is that the cases being brought to the grand jury are not adequately supported by evidence. That inference cuts directly against the basic professional standard for federal prosecutors. Schiff used the pattern to demonstrate the substantive concern with Mr. Assell's exercise of his prosecutorial authority. Schiff then cited what he described as a documented incident reported in the Los Angeles Times. According to that report, Mr. Assell was heard shouting at the Justice Department over the phone, within earshot of the grand jury, regarding the Justice Manual's requirement that federal prosecutors should not seek an indictment unless they believe they can prove the case beyond a reasonable doubt at trial. The reported language was that the prosecutor told the Justice Department they could disregard the manual. That phrase, if accurate, is a direct repudiation of the formal professional guidance that governs federal prosecutorial decisions. Schiff used the reporting to anchor the broader concern. The Nevada case Whitehouse raised and the California case Schiff raised are different in their specifics but identical in their structure. Both involve federal prosecutors operating in their offices without going through the full Senate confirmation process. Both involve allegations that the prosecutor's exercise of office departs in material ways from the formal Justice Department rules and from the substantive standards expected of federal prosecutors. Both create downstream legal risk for the cases the prosecutors are bringing. Whitehouse and Schiff used the two examples to demonstrate that the appointment pattern they were concerned about is not isolated to one office or one administration's allies. It is a systemic pattern. The institutional argument that runs through both senators' remarks is broader than either specific prosecutor. The argument is that the Senate's role in the appointment of federal prosecutors has been systematically degraded through a combination of bundled votes, acting designations, first assistant workarounds, and selective non-disclosure of material developments to senators considering nominations. Each individual workaround can be defended in isolation. The cumulative effect across appointments is the gradual transfer of confirmation authority away from the Senate and toward the executive branch. That transfer happens whether the executive branch is controlled by either party. The institutional concern is structural rather than partisan. Give all sides their due. Whitehouse used his time deliberately to put the systemic concern on the record with specific examples and constitutional grounding. Schiff used his brief addition to add a second concrete example from a different district. Neither senator was making a case against the judicial nominee in front of them. Both were making a case for institutional self-defense by the Judiciary Committee. The administration's position was not represented in this particular exchange because the witness was the judicial nominee, not a Justice Department official. That asymmetry is worth noting. Senators will need to put the same questions to the appropriate executive branch witnesses in subsequent hearings. Senate hearing speeches alone do not restore institutional authority once it has been surrendered. Whitehouse and Schiff both know that. The next steps that would actually restore the committee's role include holding individual confirmation hearings on U.S. attorney nominees, rather than en banc panels, requiring disclosure of any home court rebukes or formal disciplinary actions before the vote, demanding congressional briefings on acting and interim designations, and using committee subpoenas where the executive branch declines to provide the information. None of those steps is a single decisive action. All of them together would meaningfully restore the committee's role. The hearing record is the starting point. The action is what comes next. This Whitehouse and Schiff exchange will be cited well beyond this hearing. Future Judiciary Committee staff will reference it when reviewing U.S. attorney nominations. Bar associations writing on prosecutorial ethics will draw on the Justice Manual outburst reporting. Law schools teaching federal courts or prosecutorial discretion will use the no-bill rate framing as a clean teaching example. The Nevada and California cases will surface in academic writing on the appointment's power for years. Senators in the future considering whether to push back on en banc bundled votes will return to this transcript as one of the moments where the institutional argument was made clearly. The record now exists. There is a quiet asymmetry to this exchange that bears mentioning. The witness in the chair was a judicial nominee, He was not the proper witness for the institutional questions Whitehouse and Schiff were raising. The remarks were therefore directed at the committee record and at the public watching, not at the witness. That is a legitimate use of Judiciary Committee time. Senators are entitled to use their 5 minutes to make a record on the issues they think the committee should be addressing. The format does not require that every minute be spent on the witness in the chair. Both senators use the format the way it allows. The record is better for it. So the final accountability question is the standard one. What was gained, what was lost, and who is paying the cost? The gain is a careful institutional argument now in the formal Senate record about U.S. attorney appointments, with specific named examples and constitutional grounding. The cost is borne in the meantime by the cases being prosecuted by improperly installed attorneys, by the defendants whose convictions or settlements may later be vulnerable, by the home state senators whose blue slips are being bypassed, and by the public confidence in the Justice Department that erodes when prosecutors operate outside the formal framework. The committee can choose to act on the record or to let it sit. Senators on both sides of the aisle will be judged by what they do with it. The transcript holds the question. The public can decide what kind of standard it is willing to vote for.